we are live.
Okay, good morning. This is Senate Judiciary, final day of January of 2023. I can't believe we drew another month. But here we are, an accolade custodial interrogation of juveniles. We're at the markup stage where we're looking at what folks agree on, what they don't agree on, and on the committee particularly. But we're welcomed and joined by various folks who have provided testimony. And during markup in this committee, it's generally been our process to allow people who are in the room or who are on Zoom to comment on various issues. But it is, decision-making time for the committee. So, but any thoughts? I know Mr. Erb sent some documents by email. I don't know if we have them printed out or if they're on the committee page. You've got them, Peggy?
They're on the page. I did not print it, but they are on the page.
Could you get them printed out for the committee, please? And I'm going to start with Ben, who will outline some of the issues where there's general agreement, for example, that there's problems with the term psychological manipulation.
Yeah, so my name is Ben Novogrowski. I'm from the Office of Legislative Counsel. I'm trying to connect at the moment, but I'm having some technical difficulties to go through the new draft that's before the committee right now. So Peggy, I don't know, are you?
1.1?
Yes, 1.1. It says it's connecting, but it's kind of going on forever.
Yep. Okay.
Well,
So
the committee has it and it's on the webpage.
Okay.
would you like me to share it?
Pardon?
Would you like me to share the screen?
Yeah, if you can, that's fine. Just gotta follow Ben, so he's.
Sure. I'll work, Peggy and I'll work together to work in concert. So yeah, to your point, Senator Sears, there seemed to be some general agreement within the committee about problematic issues, one of which was the use of, or the definition and use of the term psychologically manipulative tactics. So what's in draft 1.1 of an amendment to S6, that term is struck. But just to kind of set the stage a little bit before that, so there were some housekeeping issues with the structure of the amendment. So in the previous section, 5585 was redesignated at 5586. In this version, 5585 still exists. It is just the definition section, which now gets rid of what was 5585A in the as introduced version. So that no longer exists. The definitions are all moved to 5585. Within those definitions, psychologically manipulative tactics no longer exists. And so section 1, again, nothing substantively changed other than that removal. On page 2, the committee will see that there's a new definition of law enforcement officer. This means a person certified as a law enforcement officer pursuant to Title 20, Chapter 151, which includes the certification provisions, and a school resource or safety officer. This is sort of a belt and suspenders type. When I inquired as to whether school resource officers are certified, the answer I received is that they should be, but I heard some anecdotal evidence that they may not be. So sort of as an attempt to cover both scenarios, that's why school resource or safety officers added to the definition of law enforcement officer. So again, no changes substantively on page 3. Page 4 is now the new 5586, which again substantively didn't change other than its designation. Section 3 of the bill, starting on midway on page 3, is the operative portion of juvenile interrogation. As mentioned before, all references to psychologically manipulative tactics is removed. That was in subsection A and in subsection B2A as well. And then additionally, on page 6, which is new section 4 of the bill, Section 2371 to Title 20 is added, and this is a new statewide policy mandate for interrogation methods. Basically, this mandates law enforcement agencies to adopt, follow, and enforce a model interrogation policy established by the Vermont Criminal Justice Council. It requires each law enforcement officer to follow the policy. Under subsection C, the council shall establish the model interrogation policy applying to all persons subject to various forms of interrogation, which includes some enumerated forms of interrogation as well. So it would have to cover custodial interrogations in a place of detention, custodial interrogations outside of a place of detention, non-custodial interrogations regardless of location. And I should mind you that there is no definition of interrogation in this statute. So this could presumably affect any type of questioning, but it ultimately leaves it to the Criminal Justice Council to adopt the policies themselves. And then finally, it also must concern the interrogation of individuals with developmental, intellectual, and psychiatric disabilities, substance use disorder, and low literacy levels.
Just to be clear, this section would be applicable to anybody, not just juveniles, right?
Right. All persons subject to
So
interrogation.
any interrogation would have to follow this. So we are moving in a direction, at least in this part, about the electronic recordings to run size, for everyone. And then there are specific things to this bill regarding juveniles.
Correct. And with the model policy, it doesn't mandate electronic recordings per se outside of what's already mandated for custodial interrogations in a place of detention, and which applies to all people, and also to custodial interrogations outside of a place of detention. There are already electronic recording mandates for those, but this doesn't specifically reference that. It's just to say for the Criminal Justice Council to adopt a policy across the board.
I don't see any explicit time frame that the Criminal Justice Council needs to complete that by. Is it just whenever they get around to it?
So the law enforcement agencies must adopt the policy by January 1st, 2025. This bill goes into effect July 1st, 2024. So presumably that gives them six months basically to adopt the policy before the individual law enforcement agencies need to adopt it themselves.
So we need to go over the effective dates.
Mm-hmm.
And then just a follow-up question, if I could. We've had this framework in place for a number of things where we say every agency must adopt blah, blah, blah. Then 3 or 4 years later, we find out that many of them haven't.
Right.
And there's no penalty. And I know that in the past we've, for instance, with reporting traffic stop data, we made that essential to getting state grants.
Right.
Is there any teeth in this as it stands?
So this was structurally modeled after the body cam state policy, and there is a statute within Title 20 that mandates, it explicitly lists race data collection, the body cam, and says, and any other policies established under this chapter, and it ties it to agency training. So basically the consequence is if the individual law enforcement agencies don't do it, they lose access. Exactly.
Great. Okay, good to know. I had another question, Mr. Chair, if that's all right. So I'm thinking all things considered. I'm glad that we're striking the psychological manipulation piece, but part of the reason why I'm okay with that is that when I look at what was in that, it seems like we had overlapping protections in the first version. So in other words, on page 5, it now still says a law enforcement officer shall not employ threat, physical harm, or deception. And that seems to me to pick up some of the protection that we had when we listed those 3 things in the original bill, saying couldn't deprive a person of food, sleep, etc. If you couldn't threaten them with unwarranted penalties.
Mm-hmm.
am I right in assuming that this sentence that's still in this bill, page 5, line 12, would still protect against those sorts of things?
Yeah, I mean, in the way that I would read this, that physical harm could be translated to deprivation of food and sustenance.
Threats could be threats of unwarranted prosecution, for instance.
Yeah, it could be all encompassing. And the other thing too, I noticed this in the Innocence Project suggested provisions is adding other interrogation tactics as sort of a catch-all. So that could be another way to add broader language that would ultimately probably have to be adjudicated to really determine.
Is that their wording and other tactics? Because that seems.
I believe that's what they
unnecessary.
I believe that's what they suggested, but you know, as far as the specific wording itself.
Or maybe, or other deceptive tactics.
Mhm.
Because other tactics, you know, that might include something that's not deceptive.
Right.
Okay. Okay, good to know.
I just have a quick question. So the knowingly still comes into play here
Yes,
under definition
in deception.
and deception. Okay.
There was no addition yet of adding knowingly to each clause of the definition of deception. That's something that can be done. So for instance, when I say that, if you go back onto page 1, deception includes the knowing communication of false facts about evidence, misrepresenting the accuracy of facts, so on and so forth. We could include knowing before, so it would now be the knowing misrepresentation of the accuracy of the facts, knowing misrepresentation of the law, so on and so forth. So that could be added, but my understanding is that that was still sort of an open topic of debate.
Well, it seems like the word misrepresenting, at least implies, in the same way that lie implies knowing.
Well, I wouldn't necessarily say it implies, but there is sort of in statutory construction, whenever you have a mental element, it is, if it's not dictated otherwise, it can be presumed to apply throughout definition. But again, it's not you could still add knowingly or knowing to these other aspects of this definition.
So I just got one follow-up, but maybe it's for our chair here. I know when the bill originally came through, it was juveniles. And I missed the turn or something here. At what point in time did it turn
Still
to?
juveniles, with the exception of the model policy on interrogation. We haven't made a decision whether it's going to be all interrogations or juveniles or anybody under 25 or anybody under 22 or whatever. That decision is still out there. I asked Ben when he was drafting this redraft to not make that decision, that the committee really needs to discuss where we want to go with that. So but the place where it does cover everybody is the requirement that a model policy to be developed for interrogations. And I thought that was our response to the Reed method, where we were concerned that the state police had one standard and maybe other law enforcement agencies, like we heard that South Burlington had a training in the Reed method recently. So that's where that came from.
Okay, thank you. I'm good.
Okay. Any other questions?
Just,
We haven't gotten to section 3 yet.
well, I had a question about raise the age. Back to Senator Lehovsky's original thought. On page 5, it still says under 18 years of age. And then if we do allow the raise the age to go to 19, we'd have a disjunction there. Is there a way to, that's a discussion we haven't had.
We haven't, I think I'm holding that up because it's one of those things, we're getting pressure from ACLU and other groups to move in the direction of everyone covered. Other states looked at under 25 and went to juveniles. Other states don't have raised the age that we have. So I think personally, I'm very comfortable with going to whatever the age is. I could understand under 22 because that's our youthful offender age. And all the evidence that was developed. And a bulk of the false confessions come from people who are under the age of 22. So I'm personally, but I'm happy to, this is a discussion the committee has to have, and I think it's a good test for us because it's our really first place where we may have some disagreement. And we'll see where the majority comes out and how we do it. So I asked Beth to focus on all the other things and leave the age to.
Okay. Got it.
I think political pressure in other states led them to do just juveniles.
My understanding is I think Connecticut has a bill in right now that would be doing this for everyone.
I think there's another state too that, I should tell I think there's another state that does, Mr. Herb can help us with that. I think there's 2 states that have bills.
So I was just wanting to add to the conversation about age. I mean, when I'm looking at the new definition that we have for deception on page 1, I mean, personally, I think that should apply to anyone who has to interact with law enforcement. But we're sticking to younger folks. And as you mentioned, people under the age of 22 are predominantly the ones who are providing false confessions. I'd be fine with changing the age to 22 if that's statistically and through the data that we have is shown to be what the general cutoff is for when folks are providing false information and also just easily manipulated. And also that age, I'm thinking of college students who are also their brains are not as developed as somebody who's 25 or 26, and the data does show that I think it's 25 or 26 when the brain is supposed to be done developing. So, but I could support changing it to 22, section 3.
I could as well.
I feel pretty strongly that it should cover everyone, and based on brain science showing that the brain's not fully developed until 25, if we're not going to just cover everyone, I would really advocate that we go up to at least 25.
I'm comfortable with 22.
I hesitantly agree with 22, but just listening to 19 would have been my target, due to the fact that we haven't even attained that age as of yet, and now we're jumping ahead 3 years above and beyond that. But I could support 22 at max.
Final decision hasn't been made, but maybe you could draft to 22.
Sure.
And then we'll have a decision. We know. 4 of us live with it. I respect your continue to lobby for everything.
Absolutely. I feel really strongly that our public should be able to trust that the police won't lie to them. And it's not just about the false confessions, but it's about rebuilding trust between community and police. And it's hard to do that if you think you might be lied to.
Yeah, well, things changed in the last 2 days, I guess. To the Memphis, obviously.
Yeah.
Just, so if you want to continue that, I'm uncomfortable with the effective dates.
Okay.
Might as well say that. I think it needs to be effective July 1, 2023. At the latest, January 1, 2023. And I think the model policy needs to have what Senator Baruch suggested. If you don't develop and follow a model policy, there are certain, you're not eligible for grants, just like the state of Vermont's not eligible for grants if they don't do certain things the feds require. And not that I like the feds telling us what to do, but it does make us think whether we want to use it or not. There's the one we do lose every year. We have lost funding from the Adam Walsh Act because of our refusal to provide information on juvenile sex offenders.
Right.
That's most of us, I've forgotten that actually more recently, but it's a 10% cut in our grants. But Vermont, was pretty strong. They're sealed, they're not available, and we didn't want kids who made a mistake put on a sex offender registry, and that's what the Adam Walsh Act would do.
Senator Sears, I thought the effective date clause on July 1, 2024 was for the purpose of administering the needed training to law enforcement along with developing this model policy, which still remains in the bill. So I think January 1, I think would be giving them a little more time to work on it, enforce something and put out a policy.
On the model policy, they could have to January 1. On the deception and other sections of the bill.
That could be almost immediate. Yeah.
Mhm.
Why don't we invite somebody from the Criminal Justice Training Council to ask them, how much time would you realistically need to create this policy? Just so that we're not,
It's a good idea. We're gonna get, did you have?
Yeah, I want to just voice my support for changing the effective date to July 1 of 2023. We heard from a lot of people that these deceptive tactics probably aren't being used that much anyway, so hopefully there's not a whole lot of training that needs to happen.
So we're talking about a couple of dates.
Yeah.
One for the interrogation methods, the other one for the model policy.
Yep.
Yeah, okay.
And I would agree, we should just hear from the Criminal Justice Council. I'd love to have model policy as soon as possible, but I also know that they've been kind of under-resourced, so I want to make sure that we're giving them a realistic task.
Does anybody who's here, we have Marshall, Paul, Julio, sorry.
My name is Jerome. I work for Saxon Renfro.
Oh, okay. Anybody here who would like to make a comment on where we're at so far? Anybody on Zoom who would like to make a comment? And then I'd like to hear from Mr. Timothy.
Hi, Mr. Chair. How are you? John and I are both on via Zoom, and just a couple of things. For the council, I definitely think if you had the ability to reach out to someone on the council about some of the other mandates that they're juggling, I think it might be helpful in figuring out the ability to implement. I joined the council in the fall on behalf of the department. I know they're juggling with a lot of different mandates, and they don't at present have a full-time attorney. I think they're almost there. I've been helping to push that because of the need. But I do think that would be good to hear from them, especially if there's going to be a statewide policy. I know from experience on the body worn camera policy that can be, even the minutia in that can take up a lot of time, and often law enforcement and members of the council spend extra time working on that. So I think that's a good idea to check with them, and Senator Hashim's suggestion would be a prudent one, I think. In terms of the rest of the bill, we definitely appreciate, given that law already provides for the psychological manipulation aspects, that the removal of that, I think, was something we support. And the 6 months, the different dates, I think, are just, whether it's the effective date or the policy date, that might also have an impact on understaffed municipal departments who sometimes have transitions with chiefs and whatnot. So checking in with the Chiefs Association might also be helpful. I know that they often are sort of juggling transitions of leadership. But I think other than that, there's some positive aspects here. Certainly, I know you've heard a lot about what the existing law provides for. But one thing that we wanted to note in speaking with John is the burden of proof inconsistency. I think there might have been a discussion of this previously, but having it be clear and convincing as it currently is provided for in the law, as suggested by your committee, as opposed to preponderance of the evidence, we would recommend preponderance because of the way it's already applied to law, as opposed to clear and convincing, which is, obviously a higher standard than a preponderance. But we do think that clear and convincing in this circumstance would not entirely match up with the way that the law already provides for preponderance. And then, I think that was really it. The effective date and the psychologically manipulative interrogation tactics were the two other comments. Thank you, Mr. Chair.
Thank you. Any questions for Tim or John? Julio, comments?
Just to be Julio Thompson, Assistant Attorney General, Director of Civil Rights Unit. Just to make our office's position clear on the burden of proof, we support the clear and convincing evidence standard. Our view of this bill is that this bill is supposed to change the law, and the law starts with a prohibition of this conduct. So if officers are following the law, they won't get a statement in the first place that was obtained by threats or deception or physical harm. And existing law allows that to come in if you can meet the 51% standard. So our view is that the bill doesn't really have much teeth unless you raise the standard, so that it tells officers and agencies that it's not worth the gamble, because the bill doesn't otherwise provide any personal accountability for officers. The only teeth in it is to have a disincentive to make it much tougher. And so it's less of it's more of a gamble for them. There's a price to be paid for it, and so we support the standard, and we think that the courts will be able to apply preponderance standard in one context and clear and convincing in another context. Last week I testified that happens routinely with other laws.
That was fairly convincing. Way upwards.
Not fair and convincing, just fairly convincing.
I got it, Mr. Chair. I got the joke. That was just on
Yeah. Anybody? Tucker Jones, you have your hand up.
I do, Mr. Chair. If I may make just a few quick comments. We recommended preponderance for the standard here as well. And, I went back after after I was here last, and I looked at Utah, Delaware, Illinois, Oregon, and California. And Oregon is clear and convincing, but the standard there is clear and convincing that the statement was voluntary and not made in response to false information. That makes sense because, the standard in existing voluntariness is preponderance. So it makes sense to heighten the standard if the standard is voluntariness. But here, we just have a different standard altogether from the current constitutional analysis. And the focus is on reliability, not voluntariness. And, Delaware and Illinois, it looks like they use preponderance. Delaware uses preponderance for reliability. Illinois uses preponderance for voluntariness, it looks like. And the reason we recommend a preponderance if you're going to stick with reliability as the standard is because we would like the judge to be able to watch the video, hear any testimony from the suspect or the interrogating officer, and make a judgment call based on those pieces of evidence as to the reliability. And I think preponderance should cover that. And the only concern here is that a judge may think that with a clear and convincing standard, they would need evidence beyond those three pieces: the video of the actual interrogation, any testimony by the suspect, and any testimony by the interrogating officer. And as a practical matter, I would like to reach a standard where the judge could just make a judgment call based on those three things. And it doesn't appear that there's any state that's adopted clear and convincing for a reliability standard. It looks like it's just clear and convincing for voluntariness. And Nathaniel can, correct me if I'm missing any of these states, but in my review of Utah, Delaware, Illinois, Oregon, and California, that's kind of where we came out on it as a practical measure. So that's my comment on preponderance. If I may also just make a comment on the definition of deception, we still would like to take a different approach with the definition of deception as to the first two clauses. Right now, it provides knowing communication of false facts about evidence and misrepresenting the accuracy of the facts. That language exists in the California statute, but as has been observed, there's no evidentiary provision in the California statute. It's just a standard. And so there's not really much concern about courts, how the courts are going to interpret that. When you have those two clauses back to back like that, a judge is going to have to give those different meanings. Otherwise, it would be surplusage. And so my concern is that misrepresenting the accuracy of the facts could be interpreted as applying to certain rapport building tactics that are used as a matter of course during custodial interviews. And the line is not as black and white as I'd like it to be for purposes of training of officers. So I just point that out that, if you look at Oregon, Illinois, Delaware, Utah, the language is much more succinct about what precisely is prohibited. And when you're dealing with an evidentiary standard that the courts are going to have to apply and that we're going to have to train officers on, I would prefer something that's more succinct and doesn't create a question in my mind about what the distinction is supposed to be between communicating false facts and misrepresenting the accuracy of those facts. So those are my just main two comments. Thank you.
Thank you.
They feel comfortable in speaking with you. And so I was wondering if you could expand a bit more, Tucker, on why communication of false facts about evidence could prohibit police officers from properly building rapport with people they're interviewing.
Yes, Senator, and I'll just apologize. The video quality cut out on me and I missed some of your question, and I'm not sure, maybe that was just me.
You want me to repeat it? I'm happy.
Well, I got the end of it, I think, which was your just kind of elaboration on this idea of the rapport building versus the definition of deception.
Pretty close. I think you had mentioned that the communication of false facts about evidence could prohibit rapport building, which is a very important part of interviewing. But when you're rapport building, at least from my experience, you're not really sharing evidence. You're just trying to develop a relationship and trying to build trust. And so I was just wondering if you could expand on why you think this could be problematic.
Yeah, absolutely. And thank you for the opportunity to clarify. Communication of false facts about evidence is not my concern. My concern is that the second clause there after that is misrepresenting the accuracy of the facts. And as a matter of statutory construction, a court would interpret that definition to mean two separate things. So you would have a knowing communication of false facts, and then another category would be misrepresenting the accuracy of the facts. Because otherwise, the courts interpret these things that the legislature didn't mean just mere surplusage. They meant distinct things. And I just have a little bit of a concern that misrepresenting the accuracy of the facts would bleed into the rapport building tactics used by officers. And, specifically, as you know, the rapport building often includes essentially hiding an officer's true feelings about the, potentially the repulsiveness of the alleged conduct, especially in the sex cases and things like that. And I just don't want there to be a question. I want there to be as clear language as we can, so we're not wading into that territory of how did the officer really feel about the alleged conduct, and when they were, essentially being friendly and, solicitous of the suspect.
Tucker, Senator Ruth has a comment or question.
Just picking up where we left off. So.
And then I have Marshall and Mr. Erb after.
Yep. I also am wondering about rapport building, if it's built on misrepresentation of the accuracy of the facts. So it seems to me what you're talking about, Tucker, and correct me if I'm wrong, is the officer maybe not misrepresenting, but softening the presentation of their own feelings about the facts on the way to rapport building. But this doesn't say that from what I can see. It's talking about misrepresenting the accuracy of the facts. I take that to be the fact pattern of the crime, et cetera, not the personal feelings of the person conducting the interrogation. So you're contesting that clause altogether. In other words, it seems to me you would like that clause struck, if nothing else. Is that correct?
Yes, simplified would be my preference. And the real, I think of rapport building as an example, but the real question, I think, is what is the difference between communicating a false fact and misrepresenting the accuracy of that fact? I mean, is that the same thing, or is there some specific distinction that we have in mind that, calls that into?
I'll defer to the Attorney General's office.
But if you want to, just on that specific, but I do think the language that's been suggested by the Innocence Project might take care of all of that, because the deception is knowing throughout. That's the change, I think. So, okay.
Julio Thompson, Attorney General's office. First of all, the police academy teaches the rapport building method called the PEACE method, which teaches many different means of gaining rapport, and none of them involve misrepresentation, making overt misrepresentation. The difference that we take from this about knowing communication of false facts and misrepresentation regarding the accuracy would cover situations where the accused or the subject of the interview makes a statement about the evidence that is accurate, and then the officer says that's not correct. So the person says, you're not going to find my, or no one found my fingerprints at the scene. The officer says, you're wrong about that. That's a misrepresentation about the accuracy of a factual statement that wasn't made by the officer. They didn't make any statement about, they didn't start out talking about fingerprints, but when they were asked about evidence or about the sequence of events, they made a false, they misrepresented whether it was accurate or not. That's how we think that this would be taken into account. So we didn't find it particularly problematic.
Marshall.
Thank you. So I'd just like to speak to two parts of it. First is the clear and convincing evidence standard. And I'd start by saying that we completely agree with everything that the Attorney General's office said regarding the fact that these standards are already commonly employed by courts, are employed by courts side by side with the preponderance standard, and that utilizing the preponderance standard here would essentially take a lot of the teeth out of this bill. But I also just want to talk a little bit about the qualitative sort of measures of those two standards themselves, and part of the reason why we would not want to be using the preponderance standard here. This is an analysis that only comes into play after a court has already found that through threats, physical harm, or deception, an officer has elicited a confession from somebody. So we're already talking about a place where there's already been a finding that law enforcement has violated this law. And the only question is, okay, is there, by what standard should we decide that even in the face of this violation of the law, that this confession or this admission should come in anyway? And the preponderance standard is the only standard that we really have a very clear definition of. And it just means when something is slightly more likely than not, ever so slightly. So essentially a coin toss. And what we would be saying here is that even when police violate this law and use threats, physical abuse, or coercion or deception to elicit a confession from somebody, that we would still use that confession as long as, we could look at it and say, it's, it's probably reliable. It's, a coin toss reliable. It's 51-49 that statement is reliable. And so that's what we would object to, is we think the entire purpose of this law is to try to keep unreliable confessions, unreliable evidence out of court. And when we say that we are going to sort of diminish that standard of proof all the way down to a preponderance, to where we're saying we require nothing more than just a bare sort of, 50% plus one majority to allow this in, even in the face of, already proven deception, coercion, threats, or physical harm, we think that would really just be sort of undercutting the entire purpose of the bill.
So, sorry, I know, Nathan, you've had your hand up for a long time, but I just wanted to follow up.
Well, at least he doesn't have to hold it up.
Yeah.
It's got the emoji.
So I'm trying to wrap my head around more so the clear and convincing versus the preponderance. And clear and convincing as a standard is a higher standard than preponderance, right? But it's used at a different stage in litigation. Is that, or so I mean, I'm not understanding why, if clear and convincing is a higher standard, that putting that in adds more teeth to it, because it seems like it would be more difficult to prove that deception was used if there's a higher standard.
But this is not about proving whether deception was used. This is about proving whether or not, even though deception was used, a confession should nonetheless be admitted.
I think Julio.
Julio Thompson from the AG's office, put differently, it's a standard in which the judge has to be satisfied that the state can use the evidence that was obtained in violation of the statute.
Okay.
And maybe just to be clear, because maybe I should have been clear when I was testifying, not exactly which lines I was talking about. I'm talking about lines 18 and 19 on page 5. And so that's where what we're really saying is, so subsection B says, any admission or confession or statement is presumed to be involuntary and inadmissible. And then it moves on to subsection 2, which says that presumption can be overcome if they find by clear and convincing evidence, et cetera, et cetera. So this is not the sort of doorway to finding that something was coerced or inappropriately obtained. It's the doorway for how does a coerced or inappropriately obtained confession come in anyway.
Now, having you point to lines 18 and 19 makes it much more clear now with the standard. So,
I should have
thank you.
been clearer in my explanation.
Thank you.
Okay. Daniel, we're
Thank you, Senator, and good morning, Nathaniel Erb, for the record, on behalf of the Innocence Project. I was taking notes of the question that were asked and when my name was called out. So I think the first one was other states and how they've that are considering or have considered adults. Largely, the choose, as the chair mentioned, the choice to pin it to juveniles to start was because these are the first couple states taking a crack at this, and there was a wanting to move a bipartisan piece of legislation and having it pinned to juveniles first was the negotiating ground, but not because other states hadn't wished to expand beyond that. I'll want to clarify with respect to the burden. Utah is an outlier within all of this. California is another outlier because they don't have a standard. Utah's law is actually governed by a rule of evidence that's separate from the actual text of the bill itself. So the way Utah is structured, it says if you violate the statute, the statement is inadmissible wholesale because the rules of evidence Utah require that the prosecution proves by preponderance of evidence that they abided by the statute. So that's actually the getting at the previous line of questioning. The state has to prove that they didn't violate and their deception wasn't used whatsoever by preponderance of evidence, and it's automatically excluded. So there's not even an ability to weigh whether or not the statute was violated and whether or not it's clear and convincing that it's still reliable or just voluntary. It's just automatically excluded. So they're at the highest they're at the highest bar in terms of exclusion of deceptive interrogations. In terms of the burden of proof, and I think the age kind of also fits into the way I look at this is because as the state is choosing to go, or the committee is considering, we're not moving to an automatic exclusion like Utah has. Anywhere that we parse down what the definition is or the clear and convincing standards are, we're just limiting what a court could consider. So the more we limit the age, the more we limit the definition, we're just cutting out types of confessions. We're cutting out individuals who the court would entertain whether or not their confessions are still reliable. So if we were to remove things like misrepresentation of facts or other aspects of the definition of deception, that's just people who were lied to in an interrogation, who the courts are no longer going to be able to apply this extra level of scrutiny that the bill requires. And that's also a perspective on age, is it's still saying, as I've understood it from law enforcement and prosecutors who have testified in the committee hearings, it's already the way of the past that deception is not used as a matter of policy in Vermont, and it really is just potentially in outlier cases. So it shouldn't affect the modus operandi of the state whatsoever by moving legislation that's expansive in this direction. It's just saying, if there's an outlier, we want to make sure all persons are protected, all persons are given the extra level of scrutiny over their confessions. And I agree with the burden being clear and convincing from the reasonings previously given, that we shouldn't just be 51% sure that a confession is reliable if we're allowing that confession to enter in the courtroom. Through the cases of exonerees at the Innocence Project, we continually see that confessions are just an extremely powerful tool in a criminal case. They often override exculpatory evidence, even evidence that's not corroborated, and they're just hugely powerful tools that sway judges and juries. And so not having that extra level of analysis that the bill provides for all people, or at least up to the age of 25, and not covering other acts beyond just direct, clear lies about evidence, and not including the misrepresentation of facts, would just limit the amount of people that are able to be potentially protected if training falls apart and officers violate the statute, which hopefully will never be the case and won't actually have to employ the statute.
I've got a question. Maybe this is for you, Beth.
Thank you.
So one thing I'm curious about is internet crimes, crimes against kids. There's the commonly used tactic in these investigations for police officers to, or rather detectives, to pose as underage people or underage kids to investigate and develop a case for people who are either involved in human trafficking or child pornography or both. And would this prohibit investigations of that nature?
I don't think it would, because there are certain thresholds. It depends.
Yeah.
And it depends on a few things. I mean, one, this is about custodial interrogation of people right now, 18 years of age. Or so if say, investigator is posing as somebody and is engaging in custodial interrogation of someone that is, below the threshold age, well, then these aspects would apply in that situation, but it wouldn't necessarily prohibit the investigation itself.
Right, and the person that they're investigating isn't detained also, so this wouldn't apply.
Right.
Okay.
You're thinking of something like To Catch a Predator kind of.
Yeah, yeah.
Right. So I think of that as a unrelated to this, because that would be happening as you're developing the need to bring somebody in to interrogate them. And then this would kick in. And so there wouldn't be nobody would be pretending to be someone other than who they were in the interrogation situation. I guess that's a previous stage.
Yeah, yeah.
Okay, and that's how I would understand it too, and there may be, people from the sheriff's department and others that really engage in this and probably can speak to it better than I can, but, you look at with how 5587 is drafted now, I think Senator Baruth, how you framed it is a good way to think about it, but additionally, there's the model interrogation policy that would apply to everybody depending on where the committee goes with it, and that, I think the way it's written permits law enforcement and the criminal justice council to probably account for various situations like the one that you're proposing as well. So it kind of gives the decision makers in those fields the ability to tailor the model policy based off of what they feel is prudent.
Okay. Any other questions?
I just got a quick one. I'm a little confused, and sometimes it just takes.
Colombo.
Yeah, getting to the, getting back to the clear and convincing versus ponderance of an evidence. I guess I need a little more clarification on this. And the reason why I'm thinking about this, Ben, is because a victim goes into a court of law, applies for an order, release from abuse order. And I believe it is based on the preponderance of an evidence, whether or not that victim will be issued that restraining order in this case, but also based upon that is a decision to send quite possibly law enforcement into an individual's home to remove any and all of their firearms. And that's all based on the preponderance of evidence. And I'm not saying it's right or wrong, but I'm just trying to just need clarification as to which way we're looking at this with different angles here as far as.
Well, I'm not as familiar with release from abuse orders in the process, but with this one, and as the Defender General's office and the Attorney General's office said, it's really about where this occurs in the procedure in front of the court itself, right? So this would be if the prosecution is seeking to admit evidence. I mean, it's presumed to be prohibited if they engage in deceptive, physical threats, whatever, but it then falls on them to prove otherwise if they really want to admit that statement, to show by clear and convincing evidence that it was voluntary and basically that nothing else undermined the reliability, that those tactics did not undermine the reliability. So from my understanding, a release from abuse order is really the front end. This is if you're in a motion to suppress scenario and you're seeking to admit the confessions themselves that were obtained. So it is a different process and a different procedure. And ultimately it becomes this test for the court to weigh. So I don't really know if that answers your question as far as what the standards that exist in other motions or other fields, but this one would be specific to the use of confessions in a prosecution at various stages of the litigations, and most likely starting at a motion to suppress stage.
Just to add on, and correct me if I'm wrong, I think when the legislature selects the standard, we're indicating our values when we do so. So we want to err on the side of caution to prevent domestic violence. So there's preponderance standard. In this case, the intent of this bill is to prevent deception. And so we're choosing a higher standard that the state would have to prove to show that even though they use deception, it should be admitted. So I think you're exactly right. The two standards are not the same. And by choosing different ones, we're trying to prevent both things, domestic violence and deceiving a witness. It's just in each situation, we've raised the bar for whoever erring on the side of caution to prevent those things. Does that make sense?
Yeah, basically, I'm still trying to,
Yeah.
And if I may too, it's not that the courts have they're well equipped to deal with various levels of proofs to prove. I mean, clear and convincing is not a foreign level or burden of proof that courts have dealt with before. It would just be new in this particular area.
Julio.
Yeah, Julio Thompson, Attorney General's Office. One perspective I might add to the senator's questions and comments is that in terms of different standards, that in 2017, the legislature passed a law in Title 13, which allows a state's attorney or Attorney General's office to file a petition with the court to obtain an extreme risk protection order to deny or remove firearms from the household of an individual on the basis that that person provides, a level of risk to themselves or others. The standard that the legislature used in order for the court to grant that extreme risk protection order was clear and convincing evidence. So, I mean, we do have different provisions of the law where the legislature has decided to impose upon prosecutors different levels of proof that they have to come forward in order to get what they want. And so I don't think it's not an, as Ledge Counsel said, it's not an unusual thing, and it's just I wasn't involved in the passage of that particular statute, but it does reflect weighing different values and how difficult a burden that government has to show before it does something that's going to affect an individual. And so, that's just one example.
Yeah, I do remember that. You were Senator.
Yeah.
And it was quite a discussion about what the standard should be similar to the days. And we decided to err on the caution of taking somebody's firearms away from them, that it be by clear and convincing evidence rather than the evidence that there was along both sides. Thank you for reminding us of that argument. Tim, did you have a comment?
Yeah, no, and I just wanted to say, I think this is a great discussion about where the burdens of proof are located in our statutes. And I don't know whether it's fortunate or unfortunately, I've had to use the ERPO statute quite a few times, the extreme risk protection, and routinely judges have indicated some level of, the height of that burden. And I think it's an important thing you're attempting to take away someone's firearm in that situation. But it does, I will just say this to the committee, we hope to have maybe an intern this summer, maybe do a review of all the different places where the different burdens are coming up to sort of analyze how they're being applied. And I just think this has been I just want to say, I wish that there was like a law school class listening to this, because it's been a fascinating discussion about where the burdens are coming up. And, I just wanted to thank you for the time today and the discussion throughout. And the ERPO one is definitely, I wish that the burden were lower, I'll be honest with you, for the ERPO statute, because sometimes it is the only tool that we have and we don't have a criminal prosecution. But that is a conversation for a different day. But I wanted to thank you all for the time.
There probably will be continued conversations about that. I do remember the reason we did it, and I will point out that it was the only firearm bill that did not receive in both chambers the roll call votes, and there were no votes in each chamber. Not everybody was there, but they were unanimous votes in both chambers on that bill, and I'm pretty proud of the work this committee did on that bill.
Absolutely. It's been a really helpful tool to sometimes go alongside a criminal prosecution or an RFA that's happening. The extreme risk protection orders have been increasing in terms of their usage, and certainly a very helpful tool for protection.
And speaking of law schools, Judge Zone.
Good morning, Tom Zone, Chief Superior Judge. I did want to just touch base and just to address this topic of the ERPO and for completeness. There's actually two standards that were adopted with ERPOs. In Title 13, Section 4054, which deals with the emergency ex parte grants of orders, it says in subsection B1, the court shall grant the motion and issue a temporary ex parte extreme risk protection order if it finds by a preponderance of the evidence. In contrast, for the final ERPO, under section 4053, it does say that under section E1, clear and convincing evidence. And so I just wanted to point out that the legislature actually utilized two separate standards, the lower standard for the ex parte initial order and the higher standard for the subsequent order.
Who got no vote?
And I think that made a whole lot of sense because in the emergency situation, again, you're moving quickly, you're trying to preserve due process, lower standard, but then due process at the end for the final requires a slightly higher standard.
I appreciate all the testimony, but I'm somewhat convinced that clear and convincing is the right standard. Because what we're talking about is somebody who may have used deception in obtaining a false confession. And now that person, presumably under age 22, saying, wait a minute, I didn't do this. And here's the DNA proof. That you don't need much. But let's say there isn't, and I was promised this, and this. And I haven't seen the PBS Ken Burns thing on the Manhattan group, but I did watch the movie that was on Netflix. And what those 5 went through, it's clear deception, but they served a lot of time in jail and their lives were obviously adversely affected, some more than others, but their families were also, these were not, so anyway, I'm kind of erring on the side of you. The question is, was the confession obtained through deception? If so, then it should be, if that confession is gonna stay in, it should be clear and convincing evidence that the deception, despite the deception, of course. Hopefully, won't be used much. Because I think it's a signal to law enforcement, to be honest, particularly with kids. Not use deceptive tactics. That's my vote.
I agree.
I agree that, convincing seems to make the most sense.
I would agree.
Or anything else? Are there other things that you need in order to drop 2.2? Or whatever the number, I never good at numbers. In terms of the drafting number.
This is still a draft 1.1, so I guess the next version that the committee would see would be 2.1. I think it's just, there's still the question about the age. It should be 18 years or 22. Seems like changing to 22 was the relative consensus. I just wanted to make sure.
It was 4-1, but what I'm going to suggest is we take a 10-minute break. And then we come back, and if the age is the only outstanding issue.
So there was the age.
There was the definition, the objections about the definition. We didn't settle on a vote.
Oh, I thought we'd settled on this. I thought the Innocence Project suggestion about knowing at 4 different standards, 4 different places in that step.
That would be fine with me.
Would read deception includes knowing communication of false facts about evidence, knowing misrepresentation of the accuracy of the facts, knowing misrepresentation of the law, or knowing communication of unauthorized statements regarding leniency.
Mm-hmm.
My question's not related to that.
Is that okay with everybody?
Yeah.
To adopt the Innocence Project's
Yeah.
version. Okay.
The definition of deception.
Just deception.
Yeah.
We want to break, Senator DeBruce can explain what the Colombo is.
Are you too young for that?
I'm confused.
I do have another question about something different. And I know I'm the one that asked specifically around school resource officers or school safety officers, but I'm noticing in the Innocence Project's language, they have suggested rather than explicitly naming school resource officers and school safety officers, the idea of an agent of a law enforcement officer. Would that cover that as well as others that might be acting on behalf of law enforcement?
Well, so, you know, a law enforcement agent, I mean, you probably have, that could be anyone technically that works for a law enforcement agency or is under their control essentially. And so if it was a law enforcement agent, you know, it could, because from what my understanding about the school resource officer conversation is that they are still employees of a law enforcement agency. However, their role in a school is usually dictated by an MOU between the school district and the agency itself. So yes, the short answer is that in that situation, they probably would be covered by the use of the word agent. But it could also expand beyond just them, depending on the circumstance.
Just a thought on that. You know, my first thought goes to interviews that are conducted on children. Usually, you know, there may be a police officer present, and then also someone from HCRS or another designated agency from DCF who is conducting, a person who is not a police officer, but conducting an interview of a child, a forensic interview. And, you know, I feel like there could be an issue with that non-law enforcement person having to either disregard or adopt new standards for how they're conducting interviews that are specific to law enforcement. You know, generally, yes, you know, I don't think people should be using deception and all the other things that are in that definition, but I just think there could be confusion when somebody who's not a police officer, but is part of the investigation and is conducting interviews, is unsure of what rules and regulations they're supposed to follow. If they're supposed to follow DCS rules, or now they're supposed to follow law enforcement rules. So just a thought and a potential concern regarding agent.
And an argument for leaving the definition as it appears in the draft.
Yes.
Yeah.
Julio Thompson, Attorney General's office. We would support adding agent as a way of ensuring that a law enforcement agency can't game the statute by using someone who's a non-employee. For example, sometimes law enforcement officers are involved in situations where they're dealing with private security, they're dealing with bouncers at bars. You know, I mentioned earlier that there are law enforcement agencies that already prohibit this as a matter of policy. Those policies apply to all of their employees. And it prohibits the employees from using non-employees from utilizing them to carry out deception.
But we're talking about custodial interrogation. So a bouncer at a bar can't put somebody in custody and interrogate them.
No, but an unscrupulous detective could ask the bouncer to come in and tell a false story.
Right. But
Or a retired police officer.
But that's a different thing, right? That's seeking testimony from them, not. Or you're saying during the custodial interrogation, they have the bouncer come in, and so that the law enforcement.
And he says, yeah, I saw him there. And he's telling, and the officer asked him to lie about that.
But would the bouncer then be an agent? Or they're just a citizen who's been brought in, right?
But they're acting on behalf of a person. So I think that the question really is like, if you just say, oh, if you're a sworn law enforcement officer, you can't do it. I mean, the same analysis applies. I mentioned the rule of ethics, for example. The rule of ethics apply to attorneys, but there are also different rules of ethics saying that people who are acting on your behalf, you're responsible for their acts as well. So I can't instruct an administrative employee to go lie to somebody about evidence that we have or do not have, because I'm responsible for those acts. So they extend to the acts of attorneys and their agents. So I mean, there's well-established law on when somebody is acting as an agent of someone else. You don't have to have compensation, but you're acting on behalf of someone.
We might attempt to have a break.
Sorry.
But Marshall, go ahead.
I'll try to.
Then we'll take a break after Marshall, because if we don't, I'm gonna have to leave
I will be very good. So just to explain a few situations where this can come up. So for example, in the world where we're talking about young people, we often find custodial interrogations taking place not at police stations, but in schools. That that in a school, if you have an officer and a principal in the same room, for example, interrogating a student depending on a lot of factors, including the layout of the room, the age of the student, what the student was told before the interrogation. That may be found to be a custodial interrogation. And what we would not want, for example, is we would not want a school principal and an officer to be interrogating a child and for the officer to be appropriately not allowed to lie to the child and claim that they had evidence that they didn't and so on and so forth, but for the school principal sitting right next to them to be able to go ahead and do just that. Now, I'm not 100% sure that just inserting the word agent would capture that scenario, but it is a concern that I do think, I think that agent language is attempting to get at that concern. I'm not sure.
I understand. I just think it's very squishy, and I understand the bill clearly the way it is. When you insert the word agent, I don't know what will come. Honestly.
Well, I can tell you from personal experience, that many times I've gone to police station back in the day when I worked with kids, and I'd go to the police station with the kids, and I would be there in a certain role. And I don't believe I ever lied to the kids about it, but, I was there, they were accused of something, and, I went with them. And as an agent, if I was to say, well, we'll take you back, no matter what, that could be kind of misleading, because maybe the court would say no, then DCF would say, back in the day, DCF would say, no, they're not going there, they're going to Woodside. So, I suppose that as an agent, I could be, even maybe not intentionally, but giving information that.
I don't understand how you're an agent of law enforcement at that point.
Yeah, but I'm in the room with the law enforcement.
Right, but doesn't agent imply that they're in control of you, that their agency is directing you? And I don't see that in the situations that have been brought up. So I don't see the need to
I
extend
would
it.
see myself more as a guardian in those cases.
That's what I mean.
I don't know if you've been in similar.
No, I haven't, but I would agree that in that situation, I'd see you more as a guardian than as an agent of, and that's where I think we had the conversation last week, the difference between agent of the state and this seems to be a little narrower in sort of the agents of law enforcement.
I think we have two decisions. One is really the age we'll discuss, we'll get that firm, and then the agent. And we're going to take a 10-minute break. We'll be back in 20 minutes.